public comment. This next item on the docket is the first of two opportunities, and I'd ask anyone to come forward, state their name, sign in for the record and their address, and deliver your comments in a courteous and efficient manner in 3 minutes or less. Is there anyone that would like to comment on any item on or off the agenda tonight?
Don Dresser, 1437 Grand Court. Two items. First item is the long-term lease for the community center. I think that's a great idea. It's a win-win for both parties. And it helps quell some rumors that have been rambling around in the city, some not too kind. The second item is traffic. And right now you have, public really doesn't know or understand the truck traffic coming out of Amazon, how heavy, the size of the trucks. There's still some people that think that it's only for people who work at Amazon. The new entrance and exit out of North Fork, what's the traffic for that? What impact will it have on us in exit 119? Those issues, I think, have to be made public, and you have to get some public input on it. Requesting information. I've gotten some information on Work Road. I don't understand all of it yet, but I'll eventually get there. But I got some information for Pierce County, and I got information for the Washington State DOT. And there's ongoing activity with the DOT. There's proposals on the table. They're working with JDLM. And I don't know really the timeline that would go with it, because it would help tremendously if that one of those programs were implemented. But again, it needs to be brought out to the public so that they're informed and they get an opportunity to present their input. That's it. Thank you.
Thank you, Mr. Dresser. Is there anyone else that'd like to speak on any item on or off the agenda tonight? Knowing this is the first of two opportunities.
David Bunker, 2702 MacArthur Street. The agenda item 13E. At this time, I ask the City Council not to vacate the 1975 to 1984 right-of-way at DuPont Silicon Highway lying within the Barksdale Station binding site plan on the following criteria. The DuPont Municipal Code, Chapter 1406, right-of-way vacation. DuPont Municipal Code 140605, decisional criteria. Subsection B, that the vacation will provide a public benefit and will be for public purpose. There is not a public benefit to this vacation. The 50% compensation and development of affected parcels will not benefit the city long-term if the vacation right-of-way limits access to future development of 200 acres of commercial real estate. Subsection C, the vacation shall not adversely affect the street pattern or circulation of the immediate area or the community as a whole. The vacation area will be limited to a 2-lane road, 1 lane each direction indefinitely. The following communities, DuPont, Silicon, Lakewood, Anderson Island, and North Fork, use the vacation area to connect to I-5. These communities will suffer greater traffic delays. Delays will impact quality of life and add unforeseen costs to businesses. The 2012 Transportation Impact Analysis for Project Granite, Table 3, peak hour level of service, the intersection of DuPont, Silicon Highway, Barksdale, and Wilmington, level of service, LOS, will drop from level of service B to level of service C. Delay per vehicle will increase from 15.4 seconds to 20.1 seconds. Subsection D, that the public need shall not be adversely affected. The transportation study, Project Granite from 2012, the AM peak existing is 1,169. The future AM peak is 1,624. This is vehicle trips. PM peak is 1,158 existing. Future 1,649 trips. This is right out of the study from 2012. PM increase of 491 trips and increased delay of 20.1 seconds per vehicle will be a 2.75 hour of time added to the rush hour. The peak trip counts and projected delays will prove that the businesses and residents of Historic Village and residents of Bell Hill will be adversely affected. Subsection E. The right-of-way is not or needed for future public use. At this time, there is no traffic data stating impact to the stated vacation area for future development needs. As Mr. Drescher was saying, supporting traffic for the new Fort Integrity Gate at Wharf Road and Silicon DuPont Road. The impact by the Point Defiance bypass.
Mr. Bugger, I'm going to have to ask you to wrap up.
Okay, and then the future development of 200 acres. I ask you, the council, deny the application because it is not consistent with the decisional criteria of DuPont Municipal Code 14.06.050 as per Bill Kingman, Planning Manager's memo, alternatives number 1. Thank you.
Your comments. Okay, this is the first of 2 opportunities for anyone to speak to any item on or off the agenda. Is there anyone else that would like to come forward? And as a hint, if there's any students that need credit for things afterwards, how many students are here? Raise your hand. Well, that's good. So we're gonna get at least 3 of you guys, and I don't care what Councilmember Coffey does afterwards. She will not be signing off on any school permission slips or authorization that you came here, unless at least 3 of you come up during the next public testimony opportunity and state something that's either important to you, to your generation, to your school district, or provide a perspective of something that you heard tonight. So you guys can Rochambeau, do whatever you want to figure out who the lucky 3 are, but we're not signing off on things until you actually fully participate in this opportunity. So stay tuned. We've got one more opportunity coming up. Next up on the docket here. What? No public comment? I want forward. And I'm not going to close it, students, so you have one more time here to follow this gentleman. I think this guy's a 50-year senior.
John Dane, I own a business at 1100 Station Drive. And my comments concern the application for petition for the extinguishment of the right-of-ways in the Barksdale Station subdivision. And although this process was initiated to petition for the extinguishment of the right-of-ways, it seems to be very apparent from the questions and comments from some of the members of the council at last week's public hearing that it now has become more of a question of whether the city can obtain some compensation when they extinguish these easements. The facts are such that the city now has an opportunity to correct a situation which was neglected or mishandled 20 years ago. The city established Barksdale Station as a commercial subdivision, along with a detailed binding site plan without extinguishing the right-of-ways at that time. And that's simple misrepresentation. How can you dedicate 12 commercial lots and then construct Station Drive, which crosses the right-of-ways not once, but twice, and then approve a building, the building that houses Claris Eye Center and DuPont Children's Dentistry, sits right on the top of one of the right-of-ways. And the city approved that construction also. And in the last 2 weeks, I was really perplexed by the presentations that were made that they showed the right-of-ways when it was also indicated that one of the right-of-ways they can't even really portray because of lack of legal description, but they never showed the fact that there's a building sitting on top of one of them, and the fact that the city actually built a road that crosses it twice. So if the facts surrounding these right-of-ways were presented in a judicial forum, I think the idea of compensation would most certainly be null and void. The bottom line is that if these right-of-ways are more of a liability than an asset, any demand for compensation will result in losing the potential for the construction of a brand-name hotel, which is going to provide a stable tax basis for the city, and probably will expose the city to an expensive legal battle.
Thank you for your comments. Anyone else? Any item on or off the agenda?
Yes, my name is Steve Kern. I live just across the Nisqually River in Thurston County. I'm a partial owner of one of the pieces of property. I served on active duty. I watched DuPont grow into the city that it's grown into. There was nothing here but the historic Old Town when I first came. When this particular lot that I'm a part owner of came up for sale, there was nothing, you can say shame on me, I didn't find out that there was a right-of-way, but it's true. It wasn't discovered by the title company. It wasn't portrayed as something that was a potential encumbrance of the property. We paid full top dollar, and one of the rights-of-way, which would go right through the middle of the hotel, the potential hotel site, will essentially condemn that piece of property. I know that piece of property has a greater value than $1 million. And I also have friends who are city attorneys, and I don't believe that you can essentially condemn a piece of property, which would happen if the right-of-way was exercised without compensation to the owners. What's sad is that this is really highly visible, highly desirable property. The two of the most visible lots from either DuPont Steilacoom Road or from the interstate are the two most affected lots. And they both have great potential to add to the tax base of DuPont. And I just find it incredible that at this stage we're rehashing something that was supposed to have been taken care of as a condition of setting up the binding site plan in the first place. A lot of us that are involved with this are either business owners or are occupants of that area in addition to being business owners. And one of the reasons that development has turned out so nice is that the pride of ownership has made sure that quality businesses came into that area. And I suspect if we're allowed to finish our job of developing that area, you'll see more quality businesses that will add to your tax base. Thank you.
Thank you for your comments. Anyone else? Students, you sure? Okay, 3 public comments, next public opportunity. All right, next item on the docket is thank you very much. The next item on the docket is an ordinance authorizing the right-of-way vacation. This is teed up as a first and second reading, and just for some additional comments in perspective, I know that we had some comments from the audience. I just want to acknowledge that I appreciate the deliberations by the planning agency and the outreach that was done by staff to the Department of Defense, to Pierce County, to Washington State, Department of Transportation, and others dealing with this, what I see as a housekeeping or a technical issue, which dates back to the mid-1990s, as was stated earlier. It's important to keep in mind for folks, we've gotten some questions on this, the city is not selling any of its land, we're not giving up our land. All we're doing is simply relinquishing an easement that can solely be used for the purpose of a public road that has not been used or is intended to be used by the city or any of the other government organizations that we reach out to. I just want to make sure that that's clear for people that are hearing this for the first time. I urge council to move forward with this to serve the broader public interest that will be generated by diversifying and providing long-term tax revenue from the city, for the city, from the development of this property. We have Jay Long with us tonight. He's the attorney, and he's going to provide us a brief introduction and background, and then Bill Kingman is also available to answer any questions, and then a motion would be in order by council.
Yes, I just wanted to briefly kind of go over the right-of-way vacation process, because it's my understanding the city doesn't typically have these very often. Just be good to get a little bit of background on how it works. The process is under Chapter 14.06 in the municipal code, and that is actually referencing, for the most part, state law, which is Chapter 3579 of the RCW. And the way the process works, either the city or landowners can petition the city to vacate a right-of-way. When that process starts, there is a timeline for it to be accomplished. We'll talk about that in just a second, but it's a statutory deadline where a decision has to be made. The first part of it, like I said, is that it's either petition or the property owners bring it forward. And then per our rules, there's a deadline that states the hearing, this is after a resolution setting a hearing date, but it has to be no more than 60 days or less than 20 days after the passage of the resolution establishing the hearing date, which is confusing, but essentially it says once you've set a hearing date, you have to do it per these timelines. And then it references the state code, which is 3579, which states, this is really the important part, because our code is referencing the state code, which says, they shall fix the time when the petition shall be heard and determined by such authority or committee thereof, which shall not be more than 60 days nor 20 days after the passage of such resolution. And it says the decision has to be made by then. So that's key, because at this point, the deadline for making this decision would be May 30th. So, we're butting up against that deadline. Now, as mentioned earlier by one of the citizens, there are decisional criteria for making a decision on whether to vacate property. And these are listed in the code. It's 14.06.050. And I'm not going to cover all of these, but I'll just talk briefly about some of them. First, and this is probably the most important, is the proposed vacation is consistent with the goals, policies for the street system, transportation, as expressed in the DuPont Comprehensive Plan and Generalized Land Use Map. And this is something that staff would evaluate when they get one of these applications. It's important because obviously when you're getting a road easement, at some point you think in time you may use it for a road. But if not, then obviously vacation would be appropriate. The next criteria is the vacation will provide public benefit and or will be for a public purpose. That particular requirement to me is a little general. However, I think it kind of obviously ties in with the transportation component, but also just what it will serve a public benefit. The next one is that shall not adversely affect the street pattern or circulation of the immediate area or the community as a whole. Again, this is another thing that staff would look at when they're evaluating with each request. And then just one more, there's a few more additional ones that you can look at in the code, but that the public needs shall not be adversely affected. In this case, again, staff would look at that criteria. With regards to compensation, again, our code references in part state law. And this section provides that, I don't know that I want to read the whole thing because it's kind of long and a little confusing, but basically the most important thing to keep in mind is under 14.06.080 it says, compensation shall not be required for vacation of easements held by the city for which no public funds were expended in the acquisition. And it's my understanding that in this case, there was no public funds expended for acquisition. Therefore, per our own code, we don't necessarily have to require any kind of compensation. And the important thing to look at too is under state law. You go under Chapter 3579. There's a section a really long section, which I'm not going to talk about all of it, but just the most important part of it says, now I'm going to read this sentence. It says, the legislative authority determines the grant of a petition for vacation. It shall have the authority to vacate such street or any part thereof, and the ordinance may provide that it shall become effective, not become effective, until the owners of the property, etc., shall compensate such city or town for an amount which does not exceed the appraised value, 1/2 the appraised value. So basically what that means is this is permissive. The city may require compensation, it may not. In our case, under our code, it provides that the city will not when the city hasn't expended any funds. So hopefully that clarifies the compensation issue, because I know that was an issue during the hearing, I believe, or the public comment period last week. With regards to this particular vacation, the only thing I would point out is that, again, the city did not pay for the property based on the evidence we have. And in addition, there is a 1914 right-of-way, and vacating that is not necessarily our decision. That was kind of Pierce County's decision. So in this case, the city can recognize that, but that's, whatever the prior owner has, if any interest in that property between, the private owners and that company. And with regards to cleaning up the history, I think Bill can talk a little bit more to that, to the extent that there's any questions about that. But if there's any questions from me about the process, but that's...
Council, any questions for the attorney? Thanks, Jack. Councilmember Eastep and Councilmember Quartz.
Yes, I have a question. Could you for me read the DuPont section
Which one?
in regards to compensation?
Is it possible to pull that up on the screen? Okay. So it's up on the screen there, but I'm going to read it as well. And this is, I'm looking at subsection A under 14.06.080. And it states, the amount of compensation required to be paid to the city as a condition of approval shall be in an amount which does not exceed 50% of the appraised value of the area to be vacated, except in the event the subject property was acquired at public expense. Under this scenario, compensation shall be 100% of the appraised value of the area to be vacated. The appraisal shall take into account any retained right of the city for future use which will restrict the private use of the property. Compensation shall not be required for vacation of easements held by the city for which no public funds were expended in the acquisition.
Thank you. Thank you. So, the way that I read that, we have to hear the second part of the sentence, because the first sentence, when I read it, applies to 50% of the appraised value, except in the event that it was acquired at cost to the city. And then the sentence says that at that point, it'll be 100% of the appraised value. Is that the way you read it?
Correct. However, the last sentence is a qualifier to all that. In some ways it's inconsistent with the first sentence, that last sentence, but, my reading of it is, especially the last sentence, it's pretty clear cut that if no funds were expended, then compensation shall not be required.
So it says it will not be required.
Compensation shall not be required for vacation of easements held by the city for which no public funds were expended in the acquisition.
I think one way to look at it is it doesn't say may not be required. Like in the state statute, it says, you know, the local authority may require compensation. Here it says shall not, which is you cannot do it, basically. If it said may, that would be different. We could assess, you know, an amount, and which under state law we would be allowed to do. However, our own code says shall not be required. So I guess that's the distinction I would make.
Councilmember Gassick's now, and then Councilmember Ports.
So are you saying the shall not be required is equivalent to it's not optional? There's not an option to charge compensation?
Not in this case. It's my understanding, and Bill can correct me, the city didn't expend any funds on these easements. So, you know, per our own code, which, like, again, we have the right to require compensation or not. We're saying here, we're not requiring compensation when no public funds have been expended.
I just see shall not be required, which to me means optional, but it's up to council. That would be my interpretation. Does anybody disagree on that? I know that you're saying it's...
Well, I might add, Councilmember Gassick, that not being a lawyer, I understand where you're getting at because of what's written. But and I'll have Jay confirm or deny this, but in the legal world, the term shall is a pretty powerful word.
So is will.
Understood, but will and shall actually are different in the legal terms. And while you might read it as if you're reading a book and say, hey, that means it's optional, we can do it if we want it, I think what the city attorney is trying to say, and he can correct me if I'm wrong, but in the legal world, when it says shall not, that's an end-all be-all. If it's a shall, then you have to do it. If it's a shall not, then you cannot do it. And I would ask the city attorney to comment on that.
No, I mean, that was the point I was trying to make a moment ago. It's just shall not be required, you know, from a legal perspective means you can't require it. Like, again, if it said may not be required, that would be different and give you some leeway to do what you want, you know, in terms of assessment of compensation or not for the property. But when it says shall not be required, again, it's one of those few words that when you use shall, that means you either will or you won't. In this case, it's attached with a negative. So.
Additional questions, comments, Councilmember Gassick? Councilmember Ports?
Thank you, Mr. Mayor. My understanding of the word shall is the same. We paid nothing for it. There will be no compensation. It doesn't look like you may not choose, but it says shall. I also look at that. We have no plan to use this. Now, I'm sensitive to what Mr. Munger says as somebody who lives in Bell Hill, and I'm very aware of the significant potential increase in traffic and other issues. Are waiting to see the results of the updated traffic use. But the reality is that this is a sliver of land. This is a tiny sliver of land. And in order to expand DuPont-Stillicum Road, we would have to encroach on marshes on either side. There's not developable land to expand the road. All you got is a few hundred feet here, but beyond that, you'd either cut off the front of, well, you'd have to go through the marsh on either side immediately past the easement, and then you'd be cutting off the front of Bell Hill, and then you get back into marshes again. And JBLM bounds us on the other side, which is also marshland. So practically speaking, I don't foresee any reasonable way that DuPont-Stillicum Road is going to be expanded. This is not part of the plan for the I-5 mitigation strategy. The 119 exit is proposed to come in behind Barksdale Station. It'll come through my front yard, I suppose. But I also look at this from the economic activity standpoint. We're all aware of the position in DuPont, both from a development standpoint and from a aversion to tax increases. And as the city sees a need or a desire for enhanced public safety, quality of life issues, the reality is the economic engine that's going to drive DuPont in the future comes from developing commercial property. We have more undeveloped commercial property in a municipality than any other city in Pierce County. To do anything that limits that, the vicissitudes that it creates would be a deleterious and chilling effect on business development, and I don't want to be part of that. I think we have an obligation, just as we support our residents, that we support our businesses in a cooperative venture. And this is, quite honestly, a useless piece of land for the city, but it's very useful for economic development. I also think that there's a truth in lending. We've de facto vacated this already. As was pointed out earlier, Station Road goes through it twice. It abuts on the property that we've already done it. And the reality is that this is a clerical mistake or oversight made in the past, that really this should be a housekeeping situation that we clean up and let the owners who in good faith bought this land with the intent of developing it commercially. We don't want to condemn it or place an unnecessary burden on municipal development, nor do we want to engage in a lengthy legal battle that I think we probably wouldn't be well served anyway, particularly when we have no use for them. So I think it's the right thing to do on a variety of counts.
Councilmember Gorski, and then I see Ted wants to. Councilmember Gorski.
Thanks. I guess my confusion stems from, the first sentence reconciling with the last. So what's the difference then for Jay? The public expense and public funds. Is one monetary and one is something else? Because the way I read it, you have this opportunity for, or actually it's a mandate, that you will be required to, as a condition of approval, seek 50% of the appraised value to be vacated, except, and that's the exception as I read, the event that the property was acquired at public expense. Does that mean through monetary tax dollars? Does that mean through acquisition, through like an eminent domain? So if you're going to acquire it through public expense and have a proviso to get 50% of the appraised value as a mandate, as I read it, then it's negated by the last sentence, and that kind of leads to my general confusion of the issue at large. I would follow.
I mean, I think public expense means some kind of process and expenditure of money. So that's the distinction I would suggest. However, in this case, there's been no public expense or funds expended that I'm aware of. Is that correct, Bill? So.
Correct. Well, the city didn't even know we had it until this whole thing got brought forth. So to me, I guess I would say it's kind of irrelevant, just because, if we had information to suggest that the city paid money for it, which is what you would normally do when you get an easement, right. You would condemn the property or buy it outright. But since we don't have those facts in this case, I don't know that it matters.
Okay. Understanding that, the public is defined as the citizens of the city of DuPont. So there was no public expense within the county or whoever else had part of the easement before us. Is this strictly DuPont land? This has nothing to do with county land?
I think part of it was county land, actually. Because I believe it ran along with other right-of-ways. But I mean, in terms of our vacating it and what we own, there was no public expense.
Okay. And something that's confused me as well, and it may be irrelevant or not, but is Station Road a road? Is it a public road that we maintain? I mean, so our DuPont tax dollars used to maintain, as a part of our transportation district, the Station Road? So Station Road goes through the property, but there's, as far as I see, no DuPont signage declaring Station Road. Is that correct?
Those streets in that one?
Station Drive was vacated previously by the city council. It is a private road. It is not a public road, it's a private road.
Okay. So there's no DuPont tie to Station Drive or road. It is absolutely private. It's a driveway, basically.
Only the easements for the water lines and the storm drainage lines that the city owns and maintains in that private road, those are the cities. The road surface that people drive on, the sidewalks and such are private property.
I am generally, this is a muddled mess, to be certain. I think, I'm disinclined to, based on this language, to make a decision tonight is going to be difficult, because I do think there's kind of still some ambiguity. But I am concerned that, the city did approve these things in times past, but I'm just wondering, from the state statute, if someone builds upon a property that is not unencumbered, and then, where does that liability lie? Because the city, this was known to the lender, presumably, that the city had a right of way, but was it not published? So that's where the breakdown for me becomes on, how far do we take this, and why would you build upon a site that was not unencumbered? That troubles me from another standpoint, but at the end of the day, when we are talking about traffic, the width of this right-of-way and the direction that it's set, I don't see having the value that others see in congestion relief. The congestion relief is a much bigger piece that would be required, and in part, it would have to be, just from practicality purposes, and if you are to believe the JBLM plan until it's actually a shovel in the ground, since it involves a bridge, it would have to be moved at a different point. Otherwise, you'd be shutting down that intersection for nearly a year. If you remember how State Route 18 and 520 and they're going, there's lanes closed all the time in order to expand and improve those. So I'm not convinced that easement property would be used by the city in order to relieve congestion. But I'm also not convinced that there is not a value here based on the wording here and the interpretation that we've provided again. And what I don't want to see is the city making another mistake to compound the first mistake that we made, presumably. Because I won't even go as far, and I don't know enough of the past decision to presume there was a mistake made. There may have been some logic that I don't see. I don't know, and I don't think we know. So, again, I don't know what we have, but what we're looking at here is, I think, something that's confusing a lot of us, and I don't know if I'm any closer to a reliable measure than I was last week when we discussed it.
So just to help my understanding, is the issue that you'd like to find some way to get compensation from someone? Because that's the language we're focusing on, or is it the past, how this was acquired and who owned it and all those things, which I think it's kind of been touched on before, just to help me in the staff zero in on answering some of these questions. And then Councilor Westman, you could, because I want to get some clarifications to go forward.
Well, it's not just to seek funding, but it is to be doing our due diligence as representatives of the people of DuPont on the value, not necessarily a monetary value, of really ascertaining what the value is. And there is a value of public interest that it is a road and it relieves congestion, but there's also a value in monetary terms that if there's something that we're foregoing that, we have an obligation to the people for compensation on leaving something that will not touch on relief of congestion or whatever future plan we may have for that site. So I don't see it as value, I think, as I mentioned, but I am concerned because I don't see a clear direction based on our code. That's really my main beef and problem with that decision making right now.
And I think in all fairness, and the attorney can speak to this, I mean, our code, and I'm going to shock everyone here, our code is not perfect, and this is not the only spot that there are major changes that really need to be made to just add some clarity and consistency to the language, and I hope council, as we've talked about before, will take it upon itself to bring some clarity and consistency to some of the code that's developed over the past. But I think one of the things that's important to keep in mind is also the nexus to state law in this, which I think is a little more clear than this. Ted, Jay, do you guys have anything to add to that? And I want to get back to the queue. I just want to help keep the conversation focused.
Sure, I just wanted to, since we're still kind of on the process, I tried to get this a little bit earlier, just want to let the council, and you may know, kind of a lesson learned on my part. I talked to Councilmember Koff, who gave me good feedback about bringing the city attorney to the public hearing. And while I don't think that's exactly advisable, my lesson learning going forward, because the state prescribes that timeline, and it's so tight compared to how you meet and the planning agency meet and all these steps that we have to do. One thing I noticed in this process, which if we have another vacation, I'll probably be inclined to ask you guys if we could have a public hearing. So on the night of the workshop, we might have had a public hearing, close it, wrap the gavel, and then extend the meeting and start this part of the discussion now, giving you one more opportunity to talk. So I just want to let you know that I've taken note of that, and I can help uncompress some of this for you. And then the second part is, Mayor, you just mentioned it. The other lesson learned is, it's my opinion as well, that this is language that needs to be cleaned up at a future date.
Jay, anything to add to that? If not, we'll go back to the queue, and it was Councilmember Westman and Trotter. Jay, anything to add to that?
I don't have anything.
Councilmember Westman. You have to take your vote.
The issue of compensation isn't what is bothering me right now. What is bothering me and giving me a lot of doubt about voting in favor of this has to do with the decisional criteria. And I want to thank Mr. Lundberg for bringing that to light. I am not a traffic engineer in order to make statements saying that this area has no value for transportation. I can't say that, and I don't think anyone here on the dais is able to say that it has no value for transportation and traffic relief. We don't know that. It seems to me that the criteria is put in there as a safeguard in order to ensure that the items are thoroughly explored. And at this particular point in time, I don't think they have been thoroughly explored to the point where I can agree that all of them, and it says all, must be met for the application to be granted. I have some doubts, and thank you, David, for bringing some of this to light. I would like to have further exploration by staff in order to provide data within these areas that meet or to be met by the criteria, in the criteria. The conditions were different back in 1914, 1975, and 1984 when those right-of-ways were put in there. And today we're faced with situations, and we can't foretell what the future is going to be. I'm just very doubtful about granting the application at this particular time.
And just for the record, out of respect I'm not going to have staff allocate time towards exploring the opportunity to put a public road, which is the sole purpose for this evening, through a business. I can do that analysis real quick. That's not a good idea. Ted, can you guys also give a little more context to, you know, when we talk about the intention to use this going forward?
Yes,
it
well,
has to be documented.
just remind the council of the process and some of the staff work that happened that we reviewed a little bit at the workshop, but I'll remind everybody, especially for folks here in the audience. So Jay briefed us, but you know, we reached out to the county, the state, and the federal government. And when you reach out in a vacation process, what one jurisdiction is asking another to do is it kind of mirrors our decision point E, and that is that the right-of-way is not contemplated or needed for future public use. And this is why I was struggling with Councilman Eastep's question, because I get the frustration, and I'm really hesitant, Councilman Westman, to sit here and tell you that there's no value, period, dot. Forever is a long time, and that's hard to do. But what I can do is compare my answer and our work compared to the decisional criteria. And so when we ask Pierce County, the federal government, and the state to comment, what we're asking them to do is to look at these decisional criteria and say, do you have any plans, now or in the future, that this right-of-way or this easement that we're talking about become needed for future public use? And they all uniformly responded no. So I might just say, Councilman Westman, that really no amount of time is really going to change, I think, the response we get from our partner agencies. They've made the response, whatever staff work they're going to do, they already did. Now here in DuPont, what we do is we look at the comprehensive plan, we look at the transportation plan, we look at capital facilities plan, any kind of long-range plan that we have, and we say, okay, in this area, do any of these easements and rights-of-way come into play? Is it named anywhere as to some future use? If the answer is yes, then the staff recommendation may be, yes, council, mayor, we recommend that you vacate this land as a petition request, but be advised, and then we list that out. We found no, there's nothing in any of our plans that indicate that these swaths of property would ever be used, even at the local level, in any sort of transportation plan. Again, forever is a long time. I have to go by what's written. It clearly says contemplated or needed for future public use, and the only way you can gauge that and measure that is to see what's written. And so I just would remind the council of that process. We did a lot of staff work. The planning agency put a lot of time in, and you sit here before you with the planning agency and staff recommending that you vacate this land. It is our opinion that it meets all the decision criteria. While fully admitting and granting forever is a long time, I'll tell you, as the process is prescribed and as we sit here today, I believe in staff and the planning agency believe that all decision criteria have been met.
Councilmember Shar.
We all have learned that forever is, and seeing the future is really difficult. We learned that really a lot in 2008. I want to point out that we are not the first people to see this. It went to the planning agency, which is a group of very intelligent people who were appointed to that because we thought they could evaluate this information. They had the public hearing, they did their discussion and deliberation, and the chairman of the planning agency is here and could tell you that they probably asked a lot of these questions themselves. Now the question of compensation apparently was not before them. But I am less concerned with that than I am with the question about vacate or not vacate. And I look at this property and I agree with what Mr. Ford said. There's no way that putting a little winding road like that through that property is going to relieve congestion. And we don't have a plan in the comp plan for it. And no, the comp plan hasn't been officially updated for years, but it was updated in 2006, or it was updated for a 2006 approval, but it never came to the council for approval. And in that plan, there wasn't anything about building widening the road there. Yes, there are marshes. We can't just widen it at that intersection and think like it's going to be hunky-dory. That's not going to work. I think that, you know, keeping the easement because we want to build a road through that property, no, I don't see it happening, and I don't see that really benefiting the city to have that road there. So I think that that's not a good reason to not vacate. Will it provide economic benefit to the city? Will it provide economic benefit to the citizens? Is there a positive aspect of vacating and having commercial development there? Yes, the hotels, you know, we all know that the proposed development is a hotel. The hotels provide lodging tax, the hotels provide sales tax, the hotels provide people who come here who also go to our restaurants and spend money at other locations in our city. So, you know, the proposed development is something that will add to our tax base. And if that development doesn't go through, whatever else it potentially will come in will add money to our tax base. I think that that is a public benefit, and I think that that, you know, meets the criteria that there has to be a public benefit to it. Is there a benefit to having it empty right now, a public benefit to having that land sit empty, which is what will happen if we don't vacate it? No, I don't see a public benefit in that. I am all for this vacation, and I'm all for any vacation actually, but I'm all for vacating this. And you know, I have to ask, in vacating the Center Drive property that crosses this easement, when we vacated, not Center Drive, but Station Drive, when we vacated Station Drive, did we essentially vacate the portion of this easement overlying this easement? Because part of Station, we already vacated Station Drive, and part of it goes over this easement in two places. So have we actually essentially vacated part of this easement in that vacation? That was a question you didn't want to answer. You know, regardless, I think we should grant the vacation. I'm not looking for any compensation for it. We didn't pay anything for it. We haven't used it. We don't have any intention to use it. And they had to pay us $4,000 in order to file this request anyway, so there's our compensation.
Ted, Bill, do you guys have anything to add? If not, really, Councilmember Gasson.
I don't know.
Okay, Councilmember Gasson.
I'm curious how this snafu was discovered, because it's my understanding that when this property was developed, purchased, and a loan was given, there would have been title insurance. And evidently it was not discovered at the time of the first loan. Is that correct?
I can't really comment, and I would defer to the mayor and the rules of procedure as to whether you wanted to ask petitioners how they found out. But from the city standpoint, we found out by way of petition, and Pierce County found out by way of us asking them. This was really not known by us, and you can see this in the past actions by issuing permits and everything else in the binding site plan. As we went back and reviewed, can't say it wasn't here, what happened exactly, but I can see by the documentation that the permits and everything that we ever issued in regards to this area, they never had any statements, or we never gave conditional permits, we never exercised or maintained our right on these easements and rights of way. And I would ask Mr. Kingman to add anything to that he would want to.
That's correct. The 1914 easement was created before the city of DuPont incorporated the first time. This was county land at that time when the easement was established. The city was incorporated in 1980. I'm not looking at my notes. 1980s era easement was created. That one was known, is known, and has always been discussed in city records. And the building at the north end of Barksdale Station by the site plan was constructed. The title report that was submitted to the city at that time did not include any reference to the 1914 easement to Pierce County. It was not included by the 1980s era easement because it was not on Lot 8. And neither was the other easement that we're referring to, the 1970s easement. That 1970s easement, remember, is not specifically tied down to a geographic location, because the legal description did not do it. Legal descriptions can be written in one of two ways: meets and bounds, which is a very precise way of measuring and documenting the precise location of something, or a general easement. General easements are, in this area, there will be a land set aside for a particular purpose. Again, that 1970s area easement did not show up on the title report for Lot 8 at all. When we worked on lots, I think it's 9 and 11, the John L. Scott Real Estate Building, the 1984 easement was on the table, and they did comply with it. And they were required to submit, and the city of DuPont issued variances to move the building outside of the easement, simply because they could not obtain permission to build in the easement. Fast forward to this year, Lot 1 and Lot 12. Applicant came forward and said, hey, we'd like to build a hotel. We said, hey, there's this easement that goes right in the middle of Lot 12. Got to clear the easement first. He said, okay, we'll do it. We'll work on it. That vacation request was before you tonight. Thank you.
So the 1914 right-of-way, if we didn't know about it until recently, what records were found to support the fact that there was no exchange of monies? What was found, anything?
The surveyor for the hotel on Lot 12 and also Lot 1, and researching the title chain, the chain of custody of the title, who owned it, how far back, found this issue and said, hey, by the way, you need to take care of this. Their solution was to bring a right-of-way vacation application to the city of DuPont, vacate the 1970s era easement, the 1980s era easement, and also acknowledge the 1940 era's easement to Pierce County. It's no longer being used by Pierce County. The application was forwarded to Army Corps of Engineers Real Estate Office on behalf of JBLM, to JBLM, to Washington Department of Transportation, to Pierce County, and to DuPont Engineering. All responded, no, these easements are no longer needed, no longer wanted, and will not be used at all.
I understand that part, but how do we know that there was not an exchange of monies? Was there supporting documentation found in the research that there was no exchange of monies?
The 1970s were the specific document that transfers the ownership of that 1970s easement to the city is called, it's a governor's deed, and there is no money mentioned in that deed.
Is that the same as the 1914 right-of-way?
Remember, that was between Pierce County and private property. The city of DuPont was not involved, therefore the city of DuPont would not have expended any public funds in acquiring it.
So, and if I'm misunderstanding this, please tell me, when did the 1914 right-of-way become DuPont property?
It's not.
It is not.
That's the part you're missing.
That's the part.
We're acknowledging that Pierce County has an easement that dates back to 1915, and so it's simply an acknowledgement.
So really, we only have one right-of-way that is.
Two. The 1970s were.
Okay, because I don't recall at the last meeting seeing anything about 1975. I remember 1914 and 1904.
The drawing does not show it because it's not specific.
Yeah.
The legal description does not show. It's a non-specific easement across the entire Barstow Station's project.
I apologize. I just don't feel that I have all of the information that I need and have had enough time to analyze this to make an educated vote this evening. So that's kind of where I stand, and I empathize with the situation here. I understand that you want to develop the property. I know there was title insurance purchased. I don't feel like I have enough information, so I apologize. That's just where I stand right now.
Help staff help you. What is the specific information that you're looking for? Because we may have it and be able to provide that context.
Well, I know that we had asked for an overlay of this map with the businesses, how it sits now, and I haven't seen that yet.
Bill, can you walk us through where the businesses are in this and where the right-of-way actually goes through some of the businesses?
Starting at the bottom, lot 12, there are no businesses. Lot 1, there are no businesses. Lot 2 is the Hampton Inn Suites Hotel. Lot 3 off to the right side of the page, just a Better Business Bureau building. Moving up, there's lots 6 and 7 in vertical orientation. That is a white building, multi-tenant building, that includes Starbucks, King Orthodox, Cafeteria, and turning to the right, the left of those lots, there's lot 11. You can see the number 11. That is vacant. The land area between the number 11 and lot 6 and 7 is lot 5. That is also vacant. It's not numbered, or you do not see number 5. There's number 9, number 9, 5 of those. Okay. Those are vacant properties. Going further up the page, there's a lot 8. That has an eye clinic. It is developed. Lot number 9 at the top of the page is developed with stormwater pond that collects stormwater from the entire development. That is the city's property. So if you see, key areas of the 1984 right-of-way traverses from lot 12 to lot 11 is not developed.
And where is it? Is there a specific site that this new hotel would be built?
The hotel is proposed on lot 1 and lot 12. And lot 12 is the one that has the right-of-ways on it that would frustrate the development.
Thank you.
And if I might too, would be a question of documentation. So just to sum it up, the 1914 is an easement between Pierce County and private owners. So with the question before you, no public funds, that's clearly established. The 1975 easement, we have the governor's deed that indicate no public funds. And then the 1984, I'll admit I missed it with the turning ahead, but if Mr. King would address the 1984 easement.
The 1984 quitclaim deed indicates the money, the city did not pay for acquiring the easement.
So in other words, we do have documentation that shows no public funds were expended. This is not part of the oversight as to whether or not these easements and rights of way even existed. Now that a private individual has made it aware to us, we go back and look at all these deeds and titles and everything else, and we see what money or what money was not expended. So we feel confident about the money portion of this.
Are there additional questions that you have that we can provide answers for, so you have the information?
No, thank you.
Councilmember Coffey?
Yes. Mr. Keenan, was the 1984 or 1970s easement, was it ever used? Okay, I guess let me put it a different way. Was DuPont Silicon Road in the past realigned to be where it is today?
Correct. The DuPont Silicon Road was actually further east in the general area of the 1984 right-of-way. And then it was realigned and moved west to its present location.
So there was probably state, county officials that decided with the angle of that road at that time and connecting it to railroad tracks wasn't a good idea.
moving the intersection further away from the railroad tracks was more than likely one of the goals of realigning the intersection.
Right, so you have more of a line of sight, a clearer line of sight.
More
The right
horizontal
angle.
separation between the two.
Right, right. And then also looking at that, that map that's up there, if the city were to retain that 70s and 80s, whichever one you want to look at, those right-of-ways, you see that section of property that kind of sticks out there on the corner at Barksdale and DuPont Steilacoom Road? Correct me if I'm wrong. The way the right-of-ways are right now, they couldn't be used unless you bought, the city would have to buy that kind of pie-shaped piece of property at the corner of Steilacoom DuPont Road and Barksdale.
So let me rephrase your question. If the city wanted to widen the existing location of DuPont Steilacoom Road, would they be required to purchase a sliver of that corner? Depends upon the nature of the improvements. At this point in time, the comprehensive plan, capital facilities plan, street plan for DuPont, the master plan and build out for traffic does not envision widening that section of DuPont Steilacoom Road. The traffic engineer looked at this right-of-way vacation and concluded that these areas are not necessary for build-out traffic volumes for the city of DuPont.
I guess what I'm trying to get at here is for these right-of-ways to have any value to the city and for them to be useful to the city. It looks to me, I mean, I'm an amateur at this, but I'm looking at this map thinking that for them to be of any value to the city, you would have to obtain that section of land that lays between the right-of-ways and the DuPont Steilacoom Road.
If improvements were needed to that corner, yes, the city would need to buy it. These easements do not cover that area.
And once again, I go back to the point that the angle of these right-of-ways would create conflict with the railroad and, with the angle. This is a housekeeping item, and I really feel that we need to take action on this tonight. So that's where I'm at.
And really, in simple terms, the question for the council is the sole use of this easement is for a public road. With all the information and the review that's happened from professionals and other people that have interest in this, would you like to move forward and consider building a public road on these areas through a business or going through all the other hoops that are there, or would you like to move forward with the proposal from the proponents to strengthen economic development? The council, is there any other questions or discussion for tonight? Ted?
Just one last comment, Mr. Mayor. You reminded me to bring something up, and that's a good point. Just to stress that these easements are for streets and roads. It's not something that you, the council, could say, well, that's a really nice piece of property, be a nice pocket park or something else like that. That's a good point. You have to decide you're going to build a road, and if the answer you come to is, we don't want to vacate it because someday we might want to put a road in, back to the forever statement I was talking about. Things to consider in that case then is you would be looking at, and someone said it earlier, you'd be looking at condemning the property. You'd have to buy out already built buildings, and I would just tell you from a cost standpoint, at any time in the future, if you're going to put a road in anywhere, trying to drive it through a building like the mayor said is probably not in your best interest.
Additional questions? If not, the motion would be in order by the council. Motion's been made by Councilmember Trotter and seconded by Councilmember Courts. Any further discussion? Easthead.
Yes, I think that the DMC discussion that we're having is important. I think that looking at the DMC and reviewing the criteria and understanding what the full impact of that is crucial insofar as some of the decisions that we've made in the past and the decisions that we'll make moving forward. I'll be making my decision tonight based on the facts in the staff report, also the findings, the decisional criteria, and the 7 points that were mentioned that talk about the decisional criteria, and then also the recommendation from the planning agency. So as we move forward, I think that the DMC needs to be upheld, the intent of it needs to be understood. It's too bad that this situation wasn't resolved at an earlier date, but I'm glad that we're able to do that tonight.
Councilmember Coffin.
Yes, where are we at in this clock, this time clock?
Again, subject to Mr. Kim, correct, I believe 30 May, this Friday is when the clock expires, correct, Mr. Kim?
That's correct.
So conceivably, you have a couple more days you could conceivably call a special session if it came to that. You have a few more days.
Thank you.
Councilmember Gassick.
I just want to state that I don't believe that we were given an ample amount of time. I understand that you recognize that now. But I don't like the first and second reading being in the same meeting. This is a very serious issue. There's a lot involved here, and I'm very unhappy with the amount of time that we've been given to make this decision.
Councilmember Gorski.
Thank you. I'd like to echo Councilman Eastep's sentiments. This is difficult, and I think a lot of the questions that are being vetted here has to do with like kind of a past history of some of the decisions that were made and having access to all the information. I understand there's a state law governing our timeline, so I'm disappointed that I have to be kind of forced into this decision today, but it would be nice to have a little bit more of the information put forth, at least for last meeting that we had. I know we had an opportunity to ask some questions, but not to have that generalized discussion, which kind of begets more questions and are more pointed in speaking to the code itself. So, but I think that when people in the audience hear us debating this and struggling with it, it does have to do with some of the language in our codes and our deficient codes. And whether or not you realize it or not, we have been burned in the past by these codes. And we can all throw our arms up and say, well, it wasn't us, it happened 30 years ago. But we do have to live with the consequences and understand that. I do want to just thank for the work that was done, especially to the planning agency. So I think we'll make a decision, but if some of these things are coming up in the future, again, ample warning and whatever can be done within your human nature and abilities, that would be appreciated. I'm not going to say condemn the timeline set forth, but it would be nice to have a really detailed overview that goes in with a recommendation by staff with substantiating documents. I guess that's what my point is to have the substantiation of where we were. There's a lot of questions on whether funds traded hands here, and that could have been answered in a handout that was attached to this, and we would have saved everybody about 40 minutes. So just for the future, please include that.
Any further discussion? The clerk, please call the roll.
Councilmember Coffey?
Yay.
Councilmember Quartz?
Yay.
Councilmember Eastep?
Yay.
Councilmember Gassick?
Nay.
Councilmember Gorski?
Yay.
Councilmember Trotter?
Yay.
Councilmember Western?
Nay.
Motion carries 5-2. Next on the item is a resolution updating the local government investment pool. And this actually, before we go on to that, just to acknowledge some of the comments here. As we look at the DuPont Municipal Code, this is the job of the council to set policy. And obviously, there's a lot of things that need to get done to fix the code. And you would have the full support of myself and the staff if you wanted to take a look at some codes and say, look, here's the stuff, here's the language of the issues that are most important that need to get fixed, so we can figure out a time frame. Because as a former council member, I'm as frustrated as you are to try and interpret some of the codes. And so if you all can come together and say, hey, here's some subject areas or here's some issues that we think really need some refining, we'd be glad to allocate the staff time and the resources and the legal resources to work with you to make those improvements hand in hand, so you have that resource moving forward. So we're not in this situation, again, with this issue or with other issues where you find that there's ambiguous language. With that, we'll focus on the resolution updating the local government investment pool. Sandy, would you please bring us up to speed? So with that, there's a final public comments.
Thank you, Mayor. My name is Bruce McLaurin, land surveyor, part of the.
Please state your name and your address for the record.
Bruce McLaurin, land surveyor, and my address is 1100 Thompson Road. I would like to thank you for your deliberations on the right-of-way vacation, and I appreciate Mr. Gorski's decision in light of the going back and forth, the uncertainty. A closing comment that I'd like to make is that I ask when this type of mechanism comes up in the future that the council members really take the initiative to dig into the documentation, to familiarize yourself with it, and also having gone to the trouble of going to the public and seeking public election, that you educate yourselves, take that initiative to understand some of these mechanisms. I understand that they can be quite esoteric. For example, with the compensation, that was in the deeds. When the preamble of the deed always tells what the compensation is. That information is there and it's available. I'd also like to mention that among your resources that were allocated for reviewing this was your consultant at Gray and Osborne, Dominic Miller. And if in the future the vacations prove to be as difficult as this one, I recommend that he be brought in at the front end to, unfortunately, since I'm working for the proponents of the development, I have a bias, and that's a handicap. But he, on the other hand, has the same technical expertise that can speak, fully without bias on your behalf. So please respect the work of your colleagues at the other agencies, your own consultant, and remember that the statutory limitations and the time frames, that there's just a certain compression amongst all the other agendas that we have. Thank you.
Thank you for your comments. Is there anyone else wishing to speak on it? Any
It is fun. And we'll have a block party afterwards.
That's where the Scott comes in. Councilmember Gorski?
Yeah, a few comments. One regarding dog waste. I bring this up because it's actually kind of prompted me. It wouldn't be a bad idea to have a positive reinforcement of maybe we have a small budget of Starbucks cards that when we witness people picking up the pets, we would reward them for obeying the law and being good neighbors, good citizens, and word of mouth may promote that kind of positive reaction to something like that. It might be a nice outreach to the community as well to spark conversations, and we could have precinct area captains handing that out and notice that. So for the people who step forward and note that, that's something to ponder. The second point is, if you were unable to come to the last meeting where we discussed street trees, particularly in Palisade, but in other villages as well, we had a good discussion, I felt, because we actually started a discussion. And so the question I had, I don't want to give the wrong impression, but the grant is only for a specific area in Palisade, so I don't want to give the impression of the gentleman who spoke earlier that if they're not in the affected area of the grant, that they will not see a change. It is the beginning of a process to evaluate this, and that I'm also under the understanding this is a matching grant, so there would have to be city monies involved to purchase the trees to replace the ones being removed. Is that a correct statement?
Why don't you walk us through all of this again?
So the city has a grant from DNR to look at a one block section of Palisade, as was discussed, from Hassett to Thompson. To develop a planning process by which can be replicated throughout the city. Also identifies on that one block section in Free State and go opportunities. So that's the one portion. The city's also been offered a grant that would then be able to be used for purchasing replacement trees. So kind of the reverse of what I believe I heard you say.
So in essence, it's a matching grant. So the initial phase is to remove the affected trees that are upturning sidewalks, and we would be responsible for a grant to replace, generally speaking. Is that correct?
Generally speaking, the grant would provide for replacement trees.
Okay, so what I want to have be clear is that's the mechanics of fixing the problem. Before we even get to that point, there needs to be a council-driven policy that establishes what trees will be removed, what trees will be replaced, the type of trees that will be replaced. We'll look at recommendations from some of the things happening, but that is not the end of the story. That is just actually the beginning of this. And as far as money goes, there really isn't any discussion at this point on what it will cost, because I don't think we really know in an accurate way. One of the points I brought up last week, and I've shared it with some people, is if the removal of the tree estimate is done on city time, it may be in our best interest to seek a quote to see what it would cost for a third party to remove the trees, since their level of expertise in dealing with sprinklers and utilities and other things. It may benefit us to have that be done, and that way our public works crews can actually attend to the maintenance issues that they're normally tasked with. So that's something to consider. But what I proposed last week, just so people know, and if you hear it by word mouth, there is a tree that has been identified this week. I propose to remove them all. And that's the first step, just to remove them. And that's a triage to stop the bleeding, to stop the upturned sidewalks. And then we have to establish beyond that what our policy is for repair and mitigation of sidewalks that are damaged. So there's a lot of work that still has to be done. The first discussion took place really last week. So I encourage input from the citizens on their point of view once we get further along in the process, and certainly they'll be solicited to join us. But if they have any recommendations or ideas at this point, they would be welcome. And the third and last point I want to make is we did talk about a little bit about the code, the DMCs that need to be reviewed, and I just want some clarification. We traded some emails. The signs going up at either end of Center Drive for the golf course, I am not in complete agreement that they are in complete compliance with the sign code as written. You've gotten emails from other citizens who are kind of voicing their dismay as well. So I think that needs a little bit more of a review, and maybe we'll make that time to speak of it. But There are still, from my reading of the sign code, which I did prior to the meeting, there are still some definitions that are wide open, and so we need to get around what really is required by state statute, have that incorporated and understood. Because as a golfer myself and traveling to different courses for the first time myself, I don't see signs of that nature. So we need definition on that. I do want to ask if you have a quick answer. Who erected the signs? Was that the city or was that the golf course?
That hadn't been done.
Sorry, yes, Mr. Zahn.
Referring to the specific ones.
The ones on McNeil and Center Drive and McNeil and Still, or Center Drive and Still County Road.
The two that, I think he's referring to the two that had to be put up conditional for the state requirement for 2 directional signs.
We know the city's done.
So the city's have put those up.
The city put those up. And they do belong to the golf course though. Did the city pay for the signage?
No.
No.
So, but the city erected the signs. So it
The
was
city, to clarify, I think, and Mr. Zahn, you correct, I think we sunk them because, and I'm speaking only one at DuPont or Center and McNeil, we sunk it there, as I recall, pretty brief because there's some infrastructure on there we don't want outsiders messing with. As to the one at Center and DuPont Stilcombe Road, I'm not sure what the story is around that. Did we do that one as well?
I believe so.
So what fund pays for that? Because that's promoting your business. And I'm a little bit concerned about the city getting involved in promoting a single business at the expense of the other businesses may seek promotion and permanent signage that's not on their property. There are other wayfinding signs that golf courses utilize to get you to the actual course. A great example is Druids Glen, because that's in another quadrant development, by the way. So you have to get off of State Route 18 and navigate through subdivisions of Covington to get there. But I'm concerned about using city dollars. If it was general fund dollars, that's bad enough. I don't know, does tourism dollars qualify for the labor used?
It would, and that's what I have to look at. I gotta see what funds they came out of, and I'll tell you, I'm gonna need to get back to you. You usually raise big questions about the appropriateness of this, and I'm not.
Yeah, there's no policy here that I've read, not just so much the sign code, which I can go through with a fine-tooth comb and contest, but on the city promoting businesses and events. I mean, whether it's a community event, we need a definition on that, the sign code. If this is a community event, that speaks to things that are held by the community, meaning us. But if it's a business that's promoting this, I don't want to get into having a mattress sale that I have to promote 3 miles down the road or something like that. I think it's a very slippery slope that we start doing labor and promotion work if we feel there's a benefit. But if we're just doing this as a courtesy to a business, then it's an insult to all the other businesses that work hard and go under and that come and go on through DuPont as well. They could have used more advertising and other things. So I'm not convinced that there's the state statute that fully covers that. So if we want to have that discussion, I think we should have that publicly as well. Because if we're spending citizens' dollars, if we're spending our neighbors' dollars to promote the golf course, I kind of have a problem with that. Even though there's a benefit, I do have a problem with us being that mechanism that promotes that.
Put up that sign, okay. And I'd encourage you to talk to Ted afterwards, because I know that the responses that you garnered from us and provided from us were following the email that we sent out to folks. But yeah, I think you and Ted and Pete should have a conversation afterwards. I think you'd have a public conversation. We'd be happy to do that. But, again, I go back to the sign code. Updating and fixing it was a long, excruciating process that needed to get done. It's not perfect by any means, and I'd say that's another municipal code that needs to be adjusted and amended. What's important to remember in this context is this is something that the state came to us and said, hey, there's a business that is putting up a sign on I-5, and the condition is that we add signage. And so this is what was done based on those state requirements, and we can talk about those details and look at other opportunities nowadays. But I just want to make sure that no one leaves thinking that anytime McDonald's or another business comes in, that they're going to get that exact same signage along here, because it's two different things. fixes, I think is next Monday, but we can talk about that afterwards, because this is a council
Well,
comment.
that sounds fine. And your email stated that that was, could another business do this? And you said probably not. So there's nothing definitive in policy, which council says to state that. So that's where I'm getting concerned. And any update you have on the city dollars spent to date to promote the golf tournament next month, I'd like to hear that as well. So if you have that for next meeting, can we get that number on the dollars, and that includes staff time that we spent to promote this tournament?
I can't commit to staff time, because we don't track projects here hour by hour, but I can get dollars for you. Absolutely.
Can you give me an estimate on staff?
Sure.
Councilmember Coffey and then Councilmember Trotter for final council comments.
Yes, well, I want to thank Roger for his community service project that he's going to be bringing up here pretty soon. I know he does it every year. I'm glad to see that you are spearheading that. Also, I got a quick note from the DuPont librarian, and she's thanking everyone who has returned their wild books. And you can put them anonymously in my mailbox back here, and I'll take them to the library, or they have a drop box that's open 24 hours a day on the back side of the library. So that would be greatly appreciated, because that comes out of the library's budget for their little DuPont library. So anyway, thank you.
Councilmember Trotter.
I've had a private discussion with Ted on the sign issue. I think that it should be a public discussion, because we've had emails from citizens who are no longer sitting on this dais who want to know what the story behind it. And I'm sure that there are other citizens who haven't bothered to email us who are wondering just as much. So I think it needs to be a discussion item, possibly at the next council meeting, so that everybody knows, your logic behind it, and, some clarification on it. Where Mr. Gorski's free to go and talk to Ted too, but I think it does need to be a public discussion on it. I think it needs to be at the next council meeting, because we are getting questions about it.
Any additional council comments? Councilmember Risa.
Yes, I would agree with that comment. Mr. Crowell, I just wanted to make sure that we were clear. I know that Councilmember Gorski mentioned it, but as the liaison to the tree board, there is a lot of work ahead of us, and certainly for us up here as your city council, decisions to be made on the street tree issue. It is a big problem. In fact, some of the preliminary numbers that we got so far as the dollar value is more than $600,000, which needs to come from somewhere. And so, just to be clear, the portion that is affected by the grant is from Haskell Street to the clock tower to Thompson.
Correct.
That's the only area that is affected. Anything else on Palisade, on McDonald, any of those side streets is not included in the grant, and so there needs to be a solution for that. The tree board would be happy to hear from any citizens, along with us here when we have that discussion item. It's definitely something that needs to be taken care of in the context of the trees and also the sidewalks. So we hear you, and we're gonna address this issue. Thank you.
The other thing that, just to feedback on that, to clarify and have a decision from council on really is philosophically, who owns the trees? Is it the residents that own that land and are responsible for it, as has been talked about in the past, or is it the city? And then we can figure out what the calculations are from that. But I think that's going to be another important part for the council to really decide on going forward, so that we can resource accordingly, build on the work of the tree board that's had several of these conversations. But yeah, that decision at a high level of clarifying the ownership and fixing, correcting, or affirming the DuPont municipal code is another key issue as well. With that, I don't see any other council comments. We will have an executive session, and we will adjourn. I will recess the meeting, and council will go into executive session at 9:12. 27 for 30 minutes to discuss litigation and potential litigation for RCW 4230.1101I. There will be no business conducted after we return.